In this video, I want to take a look at 3 common mistakes that employees need to avoid. I see these mistakes regularly in my practice here in Enfield and County Meath. The first thing is in relation to an employment claim or employment case, you need to ensure you don't get too personal about your employer. For example, let's say you have a case at the WRC or indeed anywhere else, for example in court. This case and the winning of it is going to depend on, number one, the facts of your case, the actual circumstances of your case. You need to prove those. Secondly, the legal issues that arise. And thirdly, then, the application of the law to your particular circumstances. So essentially, to win your case, you need to prove the facts and you need to prove the law, and then you're going to win your case if you're successful in doing so. So as I say, you prove the facts, you prove the case based on an application of the law to your facts. Getting personal about the employer is not going to advance your cause or help you win your case. So if, for example, you're bringing a claim for unfair dismissal, and the reason you've been unfairly dismissed was for persistent late timekeeping and poor timekeeping and perhaps unexplained absences from work, it is no good then getting bogged down in personal issues to do with your employer. For example, that he or she is a bully, or that he or she has poor personal hygiene, or that he or she is tight like Ebenezer Scrooge. These are personal things. They're not going to advance your case, because remember, your case is about being unfairly dismissed for persistent coming into work late. So the fact that your employer is tight as a duck's arse is not going to make any difference to your case. So that's the first thing. You need to not get too personal about your employer. You need to prove the facts, prove the law, and then you may win your case. I've seen many employees, as I say, get completely bogged down in a sort of a personal vendetta against an employer or against a manager, and it's not helpful. The second thing is expecting perfection from employer and a failure of the employer to behave perfectly, expecting that to win your case for you. What I'm saying to you is that to win your case, you need to prove that the employer has acted unlawfully, not just imperfectly. In other words, if the employer has a grievance procedure or a disciplinary procedure in the workplace and fails to follow every step slavishly and may have departed slightly from the disciplinary procedure, it may not be fatal to the employer's case. It may not win you your case. So even though they may have departed slightly from the procedure, it may not, as I say, be completely fatal, and you need not to get completely hung up and say, oh, he didn't take this step or she didn't take this step, therefore I'm going to win this case, and how much do I get? It doesn't work like that. WRC and the courts will accept that an employer, particularly a small employer, has limited resources, and perfection is not really required at all stages. So if, for example, there's a misstep or a slight departure from a disciplinary procedure, provided that in the overall context of a dismissal or a disciplinary sanction, the employee has been heard and has had a chance to put his side of the story and has had a chance to appeal, then in those circumstances, even though the employer may have departed slightly, it may well be sufficient, and you may not win your case simply because they have not behaved perfectly. So I'm making that point there in the slide. I'm basically saying that the infirmities or imperfection in the employer's case may be bad and may be really annoying for you, may be very, very frustrating for you, but they may not be fatal to his case and may not be enough to win you your case. The third thing is the catch-all bullying stress allegation. I've had many employees come in here who are disappointed with their employer. They're disappointed in work. They've been made certain promises at the outset. They've been promised pay rises. They've been promised all sorts of things. And after a year or 2 or 3, it hasn't panned out the way they expected. They're disappointed. And then they complain about bullying or stress, or the stress of not getting a pay rise, or the stress of not getting their own office, or the stress of not getting a better company car. They want to bring some sort of a claim on that basis. It's not enough. So proving an injury arising from bullying or stress in the workplace is what is required for a meaningful win in any of these types of bullying stroke stress cases. Harsh management or rough and ready disciplinary procedures do not necessarily prove bullying. And in the Supreme Court in 2017, May or June of 2017, in the Ruffley versus Board of Management case, Board of Management of St. Anne's School case, it sets out the test. There's 3 or 4 steps that need to be passed in order to prove a case for bullying or stress, that type of case. And lack of a pay rise, broken promises, or general disappointment in the employment relationship is not bullying. So don't fall into that category or that easy mistake to make and try to lump all sorts of disappointment or disaffection as a bullying thing, because it's not. Bullying cases are hard to win. You may well have a case for under a different heading or whatever, but certainly be careful that you can't just make a wild sort of assertion or allegation that because you were promised a pay rise at the beginning of the employment maybe 2 years ago, you haven't got it, or they haven't come thick and fast, then this is a question of bullying and now you're suffering from stress and you're going to the doctor or whatever. It really isn't going to be enough to win a case for sort of bullying or stress, or a bullying or stress related injury case. In all of these cases, you do need to get professional advice if you want to ensure that you don't go off half-cock with a mistaken case, a case that is bound to fail from the outset. So if you like this video, you might give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. Just to catch or to summarize the 3 tips again. 1, your case is going to stand or fall on its merits. Don't get too personal about the employer, because you're only wasting time and energy. Number 2, don't expect perfection from the employer. Yes, the employer has certain standards, so do you as employee have certain standards to maintain. However, perfection isn't necessarily required all of the time. So even if there is a slight departure, doesn't mean that you're just going to win your case. You're going to rock up to the WRC or court and win a case. And number 3 is, be careful and discriminating about what is bullying and stress, and proper proofs for those allegations, for that claim, because it can be a difficult claim to win, and you can't just gather up every grievance that you have and put it into a ball and say, okay, look, I've been bullied for the last 3 months, 3 years, or whatever. Hope you find it useful. Thanks for watching.